is up, everybody? It's your boy Andrew Esquire coming into you bright and early in the morning here in Asia. But despite the fact that when I headed out, there were no places open for coffee yet. It is so early here that they weren't even open for coffee when I went out to go get a cup of Joe. But it doesn't matter because I am full of energy taking this W here with the case dismissed in the Disney versus DeSantis case. It is full on celebration today, full on victory lap. Grab your popcorn, pop a beer, crack it open. It's going to be a good time. Of course, guys, quick apology here, and that's actually my alarm for when I was supposed to wake up. But hey, listen, stuff happens. So listen, we're going to be going over this entire decision. We're going to be going front to cover on it. We're also going to do some catch up on the copium because people are already starting to cope here in the chat. And of course, we are going to do this all live because yes, this is really, really, really live. And we are going to, we're going to crank it here today. But yeah, it's good to see everybody in the chat, and shout out to Roscoe Remington, who is the first in the chat today. So shout out to Roscoe. Hope you're doing well, and thank you guys for joining me on YouTube, on Rumble, wherever you are today. We're going to have a good time. I do apologize for any echo. This is not my normal studio. I am traveling. I will be back in my main studio in Bangkok tomorrow. So 24 hours from now, I'll be back there. I'm actually flying out in about 12 hours from now. So I'm going to be hopping on a plane. So this is a temporary setup. This is my travel setup. The room here has horrible acoustics, so I'm sorry about the echo. Mi scusi, but I had to come out and stream on this live. And this is why I always try to keep my travel streaming set up with me. I keep my webcam. It's not as good as my regular cam. I have my microphone, which I've gotten down to kind of the travel size here. That's all a little bit dusty there, but it's all good. Works out just fine. And I got my new laptop. I got a brand new laptop for travel streaming because my old laptop was kind of too heavy, clunky, having some issues. So I got a brand new laptop. So I invest in these things so I can break news to you when it breaks, just like this. So yeah, super excited. Bert Macklin, for a member for 1 month, says, "Let's go!" What's up, Bert? Hey, Bert, let me say thank you for tagging me on Twitter throughout this battle, this Disney v. DeSantis battle. You've been out there slaying the pixie dusters, and today the copium from them is going to be amazing. In addition to the silence. Because it's either people that are just going to shut up because they don't know what they're talking about, or people that are going to cope, and they're going to cope in a very predictable manner. We're going to talk about that and address that. Also, quick shout out to the 199 to the Geeks and Gamers squad. I got a call this morning from Valiant Renegade, who is out there being an absolute nerd, and he was out there at Universal. So I just want to say shout out to those guys. Obviously, I will make the rounds, right? So I will be on other people's channels. I will go on Geeks and Gamers. I'll go on Valiant, WW Pro, all these other channels. I'm going to go on and do the victory lap. We'll talk about this with everybody, but you've got to hear it first here on my channel, The Legal Mindset, where I provide the most in-depth analysis, period, right? When I go on somebody else's show, I give them the quick points, I give them the TLDR, but they don't get the full breakdown and full understanding of the law like we do on my channel. So shout out to everybody there. And thank you, Tank Rap, for the 20 Legal Mindset memberships. Thank you so much for supporting me. And also, guys, please say thank you if you received one of these memberships from Tank Rat. Steve C., Azurian, Mary Ann, Tiger's Dad, Dr. Megatron, Sebastian Simonson, Stephen Williams, Final Monkey, Mark C., Jerry Jones, Steven Severance, Spooky Spoon, Asgardian Blade, A Madman, Mike So, Haxor, David Musrain, Mamasaurus Rex, and L. All you guys say thank you to Tankrap for hooking you up with those memberships, and say thank you to everybody who's been coming through big with those memberships, which has helped support my channel. Another thing you guys can do, if you really want to support me today, we have one thing you can do. We are in the final hours of my Seedy Creek project, which I don't know, may have to be updated with this W, but we are in 10 hours left for Seedy Creek to back this project. If you haven't backed it, Get over there and back Seedy Creek. There's nothing I would appreciate more with this W than that. And let's just say this may have to be an update to the comic. We may have to have that extra page in the comic that's slapped in there about that decision. So make sure you go over here and check this out. Seedy Creek, it's on IndieGoGo. I will drop that link in the chat, but this closes in 10 hours. Now, we may have a book version out, a hard book version, but we haven't gotten quotes on that. So what we're going to do is that will go up as a separate thing. It will go up as a separate project, the physical version. This is the digital delivery version. So this will be digitally delivered quick. So if you want to support that, go over here and support Seedy Creek. This is going to be an amazing project, and this decision only makes it that much sweeter. So you guys can go check that out, and I'll post that in the description. And I will actually pin that so you guys can see that as well. So just thank you very much for all your support, guys, whether you're here in the channel or anywhere else. So thank you, guys. Quick super chats here. Wait a second. Did I already get these 10? Is 20 or are these another 20? Hold on. No, that's the first 20. That's the first 20. All right, got those. Thank you, Tank Rat. Steve C says, who is the imposter, Steve C? What the? Wait a second. There's more than one Steve C? There's more than one Steve with a C last name? I don't believe it. I don't believe that there's more than one C last name with a Steve. I'm shocked. I'm shocked. Little Rock says, great to see you live. You know I'm going live on this topic. I'm going live. This is all me. This has been me for over a year. In fact, I went back to talking about this 2 years ago. Nobody was talking about it. And everybody said I was wrong. Remember Legal? Remember that guy, that little schmiegel? Remember Leonard French? Both of these Disney simps, these liberal, cucked out Disney simps who, oh, it's free speech. They don't understand Florida law. They don't know special districts. They didn't bother to speak to anybody that even knows this area of law or that even is a Florida lawyer. These people relied on the talking points straight from Disney without actually looking at the law. They are shams of lawyers if they can even call themselves that. And yes, I know they can legally call themselves that because of their credentials and because they pass the bars in their state and they pay the fees and they do the CLEs. But they do not have the spirit of the lawyer because they're not thinking critically about it. And look, this is something that if you know the law, which I know the law more than anybody else out here on this specific issue, it is very clear. It is absolutely clear on this. And it always has been from Jump Street, period. Florida special districts can be created and destroyed like this by the entity that created them. You're going to see this, and I'm going to show you this in the decision today. I'm going to show you where the judge says this explicitly. So we'll get to that today. James Beaver, member for 6 months. Thank you so much for supporting the channel. Changer of the Ways for 5 says, FYI, cutting down on Super Chat, had to grab some cast stocks. Hey, listen, man, all good. Hey, listen, Epic Universe is going to be huge. Get in there, buy all the Comcast you can. I'd appreciate you checking in. I appreciate you sending the 5 and appreciate you just being here, Change of the Way. So thank you so much. Guys, you can also say thank you by smashing the like button. We've got 600 people here and only 175 likes. Let's get up to 300. We can get up to at least 50%. Give me 50. We can do 50. So let's get up to 300 likes, guys. Just smash that like button. Gunner says, but if you scream, DeSantis sucks while you drive drunk, the state of Florida can't arrest you. This is what pixie dusters actually believe. Yes, they believe that their ability, their speech allows them to do whatever they want. So if they say something and then they're punished based on a totally reasonable, legitimate law, based on saying that, that's impermissible. That's exactly the same thing. This logic is exactly the same as what they're saying. That they can yell and scream and, oh, that makes something that is completely legitimate that the government can do suddenly illegitimate. Well, no. You don't get to just yell and scream and say, well, I get to get away with whatever I want. That's what a petulant child does. But Disney has been a petulant child, and they've gotten away with that for decades. Legal manlet. Yes, he is quite the manlet and quite the horrible takes. In fact, I actually appreciate him being there because those horrible takes give me something to lampoon and to absolutely wreck. And I do hope he does. I hope he does a follow-up video. Please do a follow-up video. Please do a follow-up video, Legal Manlet. It will be great. Invader Talk says, man, Disney keeps taking L's, and it's not even February. No, and we're not even done. Guys, this is the federal case. Now we've got the state case. And when they lose that state case, oh boy, oh boy, oh boy, it is all over for them. When they lose that state case, which now it is looking like they very well will do, because remember, Disney has always hung its hat solely on the First Amendment argument. They've never made any cognizable argument about Florida law. So they're going to lose that Florida case because their whole argument, they put all their eggs in this basket without even acknowledging Florida's special district law at all. Any of the arguments they might have under that. They've just solely argued on First Amendment. That's it. That's a loser. That's going to be a loser. And because of that, they're going to definitely lose in the state case because they put all of their eggs in this basket. They had nothing else. And this is what I said from the beginning. Disney's legal team, they hired a person from DC, California, New York. If they hired somebody who knew about this, they could have made a better argument. Disney didn't even have their best defense. There's better defenses for this. There were better defenses. They didn't make those arguments. And they didn't hire me. I'm just saying. They could have tried. I wouldn't have worked for them, but they could have tried. I would have been conflicted out. I mean, between working for, at some point, you're working for Universal, Celebration, Bonnet Creek, Reunion, every other special district surrounding Disney, I'd be pretty conflicted from representing Disney on this one. In addition to knowing that Disney did, literally hearing from Disney staff professionals that they were doing things wrong in Reedy Creek. They literally were saying, we know we're doing this wrong. We don't care. I've heard that. I can't represent somebody where they've told me they're doing something that is unethical, impermissible, and very likely illegal, as we'll find out in the future. So I would have been conflicted out from Disney. But that being said, they should have. There's other people that know special district law. They didn't hire them. I know them. They didn't hire any. How much will this cost Disney? Well, obviously, it's cost them lawyer fees, their own lawyers. So they've paid their own lawyers a lot of money on this. They've lost that. Now, this isn't one where they're going to get fees and awards and stuff like that. It's a case dismissed. So they're paying their own fees. They're walking out of court paying their own fees on this. So it's cost them a good amount of money. But what will really cost them is the state case. That's where the trillions comes in. And I know a lot of people, in fact, the same people, let me post the same. Let me show you a little bit of the copium here. So there's this one channel. I don't know if you guys know them. It's the DSNY newscast, right? So let me put them up on blast here for a second. I think this is them. So this should be them. Now, here we go. DSNY. Finally, Walt Disney World is suing Governor DeSantis, a targeted campaign of retaliation orchestrated every step by Governor DeSantis as punishment for Disney's protected speech. I reply, never get high into your own supply of pixie dust and try to listen to folks who actually know. I don't know, understand this area of law. Yeah, these guys, for the longest time, DSNY has been out there just really high on this First Amendment supply. They've not believed anything we've said about the costs of this, that this will be trillions of dollars, not today or tomorrow, but over 100 years. Yes, with inflation and with these costs and expenses over 100 years, yes, this will be trillions of dollars. That's unexpected. That's straight up when it comes to the state case, when it comes to what they're going to be able to do and what Disney has now lost, because Disney is never going to put this genie back in the bottle. At best, they may be able to retain some minor development rights. That's something I can get into in more nuance when we talk about the state case. If they had good attorneys, they might be able to make those arguments, but they haven't made those arguments. There are arguments for Disney to make, and I don't want to give them the arguments because at this point, they may be watching my videos. I don't want to give them the arguments. But the thing is, they could retain something. They could retain certain protections, but they've made none of those arguments. They made none of those arguments. I see no wall of unread law books. You shyster. Yes. You just see a closet in an Airbnb. So sorry. Yeah, horrible situation with my closet here. Melodious says, did you see James O'Keefe's ex-post bombshell in the White House? Then we'll talk about all other topics later. There's going to be a day for everything else but Disney, but today's Disney Day. Come on. But that being said, thank you so much. And obviously, I love James O'Keefe. Support him. Horrible what happened to him with Project Veritas. So just shout out there. Senior Schnitt says, I'm paying you €5 just to say, F you, legal. All hail our boy Mindset. Also, is this not pre-recorded? No, it's live. And I see people smashing the live button out there in the chat. I want to see those live emojis out there because we are indeed live. We are indeed live. 100%. Floral says, your mic sucks. Get out of the airplane toilet stall. It's the echo of this room. This room is super echoey. It's all bounce. This is everything around here is bouncing. And the floor is super echoey. This is a horrible setup. So can't wait till I'm back in my main studio, which is much more padded. We'll call it that way. Lily Smith has been a member for 11 months. Says, hey, Andrew. Hey, what's up? And Opus has joined as a member. Welcome to the RPG, Opus. Welcome to the Replay Gang, and love this wall of green. All right, we're caught up now with everything going on over here. And also, quick shout out to those on Rumble. Appreciate y'all. What type? If somebody asked on Rumble, what type of laptop did I buy? This is an MSI. Oh shit. I have to look at the exact specs on it, but I know it's got a good enough graphics card to stream. And pretty much, I didn't buy anything that was I didn't buy anything too expensive or whatever. I wanted something that, look, I'm traveling. If it ends up getting damaged or nicked or whatever, it's not going to be a huge like I can replace it. I think this one ran me about 25,000 baht, so under 1K USD. So it was a pretty good price. And it was light, had a good enough graphics card to stream. I'm only streaming on this. I don't do anything else on this laptop. It's pure work, pure streaming, actually, period. I only use my editor for thumbnails and videos, and then OBS. And that's it. I don't keep anything else on this. And then a file that says Disney. I'm not even shitting you. I have a file on all of my computers that says Disney files, and I've got stuff to pull up on all those files. So that's all I got. I don't keep anything on that because this is for you guys. This is for business. This isn't for pleasure. Hillis Mallory joined as a new member. Welcome to the RPG. Ted Park for Canadian $5 says, I guess when you're traveling, you need to go light and not carry your collection of unread law books. Yeah, nobody reads those law books. They don't even know what they say half the time. In fact, a lot of those people, they're just backgrounds. They're not a virtual background. They're not even real. So that's the other thing about the law books. It's the most pretentious, douchey thing ever to have law books. And frankly, that's usually the people that don't actually practice or really do law day to day. When was the last time you had a drink with Jeff? I came over and saw him when I was in Korea. I saw him very, very shortly. So Jeff and I drink in real life. Not just online. Shout out to Ron Coleman. I know Ron's been a good ally on this and come around on it. So appreciate Ron. We had a great conversation on his channel, the Coleman Podcast. And I appreciate getting a lot of support from Ron on this. So shout out to the old Coleman on this. So let's jump right into it already. Without further ado, let's get right into the decision itself and read through this one today. So let's see where we have it. Oh, and thank you, Lele, for the 5 gift memberships before we start here, helping people out in the chat. Maka Voxel, Spy Hero, Jerry L, Super 23 Super, and Jason Purett. You guys say thank you to Lele for those memberships. All right, so here we go with the actual decision. And let me get this. So here's the decision. So this is in the U.S. District Court for the Northern District of Florida, Tallahassee Division, Walt Disney Parks and Resorts, Inc. versus Ron DeSantis and Governor et al. Defendants. So remember that this case was not just against the district. It was also against Ron DeSantis. And one of the key errors here, the fundamental errors of this case, was they sued Ron DeSantis, who should never have been a party to this at all whatsoever. They shouldn't ever have added Ron DeSantis to the secretary. But the reason why Disney did that was because a case was a lot sexier to say this is a DeSantis case than to say this is against the CFTOD. So this was something that always was postured in a way that was meant to have a political effect. As much as Disney lately has been saying this case was for Ron DeSantis, no. This case was for Disney. Disney was the one who sued DeSantis. They tried to flip this narrative and DeSantis picking on them, but they're the plaintiff. Look at it, plain and simple. The pixie dusters do not acknowledge facts. They don't like reasoning here. And the thing is, Disney was the one that brought this failure upon themselves. They did this to themselves. Speaking of doing this to themselves, congrats, Ron, on hitting 10K on your channel, the big 10K. I remember when I got to 10K, it's a road to 100K, and you deserve it, my friend. Dan Stafford says, Disney tears, let them flow. Oh, you know. And Big Blue Horses says, I predicted the WW win because judges are activists, bench legislate. I posted that in a thread a while ago. I was wrong, just saying in public. Dude, Big Blue Horses, I have a lot of respect for you for that. And also, I will say this. If it had been the judge that hated DeSantis, the one that got recused off of this case, it would have been a Disney victory. He would have just given it to Disney on some whack morale because, well, it would have been an activist in this. This judge followed the law. And by the way, I'm going to get into the copium about, oh, this is a quote unquote Trump judge. We'll get into that a little bit later. But guys, remember with those arguments that Trump initially attacked DeSantis on this. And initially, Trump defended Disney for a second, for 1 minute, because there were conservatives that were defending this as a First Amendment case before they got educated on it. But then people that were Trump supporters, and also I think Trump himself, got educated on this, and they actually learned the real law, and they figured out, oh, wait a second, this is a state law thing. This is something you don't want to get on the side of woke Disney on because they are wrong, and they're clearly going to lose under state law. So they got educated on it, and they came around. People like my good friend Robert Barnes. Robert Barnes came out initially and was like, oh, this might be First Amendment. But then he got educated on it. He said he listened to me and said he got educated on this, and he changed his mind, which I appreciated. People listening to people that are experts. Look, I defer to about everybody else when I discover they're an expert. If it's maritime law, I would defer to Jeff, my friend Legal Vices, because he does a maritime lawyer. My little niche in the world was special district law. I've done other types of law, and nowadays I'm doing a lot of immigration, a lot of U.S. immigration stuff. So obviously and I've done other areas of law, but for about a decade, I did special district law. Easy to confirm. I'm out there. I'm as their counsel. I go to these meetings. I'm in the meeting minutes. You can go back and see me at Celebration and Reunion, Bonnet Creek. I was in all of these places. And this is what I know. I know it from going to thousands of meetings and knowing Reedy Creek folks. So I knew they were going to take an L here. Mexican Iron Man says, Deadline and other shill sites are still writing that this is a setup. But let's be real. Disney's saying they'll keep fighting, but like, where would they even file and what would they even file or appeal? Yeah, the appeal is going to be pointless. And some people have asked me, what do I think about that? Look, good luck with it. You're going to lose on the same ground. SCOTUS is not going to give you standing, okay? This would just draw it out. All it would do is delay, but they just lose again. And now the narrative is flipped. Now they can't deny that they've lost. They've lost. At this point, they've got to redeem their loss. It's not going to happen. They can't magically generate standing where there is none, and they can't magically generate a claim. This was a motion to dismiss. This is not summary judgment. You know how hard it is to lose on a motion to dismiss? It's very hard. And it's very hard. All you have to do is state a cognizable claim. You don't actually have to prove anything. In fact, as we'll see when we read this motion, they have to construe every single fact in the light most favorable to Disney. And if a judge, even construing that, cannot find in favor of Disney, there's no chance. There's no chance. The rat trap was snapped. AKA, we need a rat trap emoji. Good one, Natasha. I will get on that for sure. Jonas J. Campbell, good friend of the channel, member for 8 months. The Ocho says, first Epic Universe, now this. The Pixie Dusters are having a rough year, and we are having a great year, aren't we, Jonas? Aren't we? It's good to see it. You love to see it. All right, so let's get into this analysis here of this actual order. Okay, so in 1967, this is an order granting a motion to dismiss. Once again, a motion to dismiss, you presume all facts in the light most favorable to the plaintiff. So everything in this, everything is being presumed in Disney's favor, every single fact. So in 1967, the Florida legislature created Reedy Creek a special district in Central Florida. The reason why they start with this, and the reason why I have been right this entire time, is because all of this relies on this being a Florida special district. All of this law turns on that. All of this law turns on that. So it turns on the fact, okay, Scribe, I don't want to log into your account here. But all of this turns on it being a special district, so special district law applies, right? So this is what is most convincing, is most persuasive for the court, is the fact that this is a special district. The district was best known as home of Walt Disney World, which operated there for decades. As the district's largest landowner, but key here, largest, but not only. Here's the key, but not only. Has effectively controlled the board whose members were elected based on land ownership. That changed last year after the Florida legislature substantially amended the governing statute. Now, Florida's governor selects the board, subject to Senate confirmation. So the Senate is involved in the process as well. So you've got to invalidate not just the governor, not just Ron DeSantis, but the entire Senate. You've got to overturn the entire legislative process. Okay? As a result, Disney no longer controls the special district in which it operates. The district is now called the Central Florida Tourism Oversight District, or CFTOD. That's what we're going to be referring to it as. No longer Reedy Creek. We call it CFTOD now. The change, which works to Disney's significant detriment, came after Disney publicly criticized another Florida law, the Parental Rights and Education Act. In Disney's view, this timing was no coincidence. Disney alleges that the Florida legislature changed the governing statute to punish it for its speech. The issue is whether the legislator's action, so whether the legislature constituted an unlawful retaliation for speech in violation of the First Amendment. The defendants are the governor, the secretary of the Department of Commerce, and all the members of the CFTO board. All defendants moved to dismiss. So everybody wanted to dismiss this. The governor and secretary argue lack of standing and 11th Amendment immunity. The CFTO defendants argue their failure to state a claim on the merits. After hearing and after considering both parties' arguments, I now grant both motions. In short, Disney lacks standing to sue the governor or secretary, and its claims against the CFTOD fail on the merits because when a statute is facially constitutional, a plaintiff cannot bring a free speech challenge by claiming that the legislators who passed it act with constitutionally impermissible purpose. What does this mean in a nutshell? What this means is when on its face, it is legitimate. You cannot call out and scream, well, but you did something mean to me. You said something dirty to me. No, there are a number of legitimate reasons for getting rid of this, and it is completely permissible to get rid of this, right? So because of that, because it is completely permissible to get rid of this, yeah, that's something that can happen, that can. There's definitely an issue with that there. All right, so let me get this here. Lily Smith says, I watched a video by Legal. He insulted you in it. I've not seen any videos. I just checked the channel right now. He didn't say anything about me. I left an obnoxious comment about it, listening to a real lawyer. Happy we were right. He has never name dropped me specifically. That's not true yet. I haven't caught him. If you guys have caught him, you have to clip me and send it to me. But I haven't seen Legal name dropping me yet. He may do it now, but because I called him out and I called him a manlet. But that being said, he doesn't know this area of law. Look, he's a civil lawyer from California who's never done property law in his life. He doesn't know anything about special districts. California has nothing akin to this. They don't have this set up. They don't have these types of laws. He doesn't know this area of law. So it's just somebody who's talking out their ass on an area of law, which is going to be nothing new. There's going to be a lot of attorneys that just want to spout out like an autist the First Amendment argument without actually thinking about the law critically or deferring to somebody who knows a little bit better. Just saying. All right, let's get into the meat of it. Before proceeding on the merits, a federal court must ensure its jurisdiction. So they obviously have jurisdiction here. Because the standing doctrine is an essential and unchanging part of the case in controversy, if Disney lacks standing, the court may not consider the merit of the claims no matter how weighty. So what you have to understand is standing comes before the merits. So if a party does not have standing, we don't even get to the merits of the claim. So against the governor and against Ron DeSantis and the Secretary of the State, they do not have standing. Standing requires an injury in fact that is fairly traceable to the defendant, and this is the important one, is likely to be redressed by a favorable decision. So when there's a decision that will fix the problem, here's the thing. A decision here would not fix the problem, and therefore there's no standing, in addition to those other things. But the last one is the real killer. At this stage, all Disney must do is allege facts that, if were true, would support each element. As explained below, Disney has alleged enough for standing as the CFTOD, but not as the governor or secretary. So the CFTOD, the Central Florida Tourism District, never argued standing, okay? So the CFTOD never argued that. And I always said the only party they have standing against is the CFTOD. That's the party they have standing against, is the CFTOD. They should have brought this case against the CFTOD, and they would have had standing. It would have gotten dismissed on the merits, which is what happened here, but they would have at least had standing. They would have at least had standing. And guys, I know the sound is not premium today. Please bear with me. It's the travel setup. So obviously getting it to you as the best I can. And let me get back to this. Before the legislative amendments, Disney enjoyed voting rights in the district, which regulated its property. Now it does not. Now it faces land use decisions by a board over which it has no control. Disney's loss of control is enough to constitute a constitutional injury. That injury is clearly traceable to the board that now makes land use decisions affecting Disney. The last element, redressability, often travels together with traceability, and also is present here. An injunction precluding the CFTOD board from exercising its authority would redress Disney's injury. So what they're saying is, look, there would be a way to stop the CFTOD. Now, whether or not that's just or right is not the question. They're just for standing purposes, for standing only, which means, can they bring a claim? It is possible to stop the CFTOD. It's not possible to do anything against Ron DeSantis in the legislature. You cannot issue an injunction against the governor in the legislature saying you can no longer pass any more law. That's not possible. You can't do that. The CFTO defendants argue with some force that an injunction could not restore the previous regime. An injunction could not, they argue, allow Disney to gain its own electing board. But the relief sought not to compete for standing. Instead, even the ability to effectuate a partial remedy satisfies the redressability. So they would have standing against the CFTOD. However, they have not shown standing against the governor or secretary. As the governor, Disney alleges traceability on two bases: the governor's power to appoint CFTOD board members and the governor's quote-unquote actual control over the CFTOD board. Neither basis works. To the extent that the governor contributed to Disney's injury by appointing board members, that action already happened. It's in the past. It must allege an imminent future injury. There is no future appointments that are going to happen that are imminent. We've not shown at all that he's going to appoint new people, and also that it would make any difference to stop those future people. Disney would face the same situation it faces now. It would be operating under a CFTOD board over which it has no control. Stopping hypothetical future appointments would not address any imminent harm. So the people that are appointed are not going to stop the harm. They still have the power over Disney. Disney would want that power back, and they're not going to get that power back. To the extent that it contends the governor is exercising actual control, he's not on the board. He appointed people, but they're individuals who are able to vote on their own and do whatever they want on their own. Allegations that the CFTOD board operates as a state receivership under the governor's thumb are conclusory. There's no facts to back that up. Disney has not alleged any specific actions the new board took or will take because of the governor's alleged control. So they have not shown a single specific action that the CFTOD has taken that has been because Ron DeSantis told them so. In fact, Disney has not alleged any specific injury from any board action. Its alleged injury, as discussed above, is it's operating under a board it cannot control. That injury would exist whether or not the governor controlled the board, meaning an injunction precluding the governor from influencing the board would not redress their injury. Disney has not shown standing to sue the governor. Boom, done. Case closed against Ron DeSantis. That's it. That's the case against Ron DeSantis. Next, the secretary. Disney struggled to articulate any injury attributable to the secretary. At best, it contains the secretary maintains an official list of special districts. Okay, spoiler alert here, guys. Back when I did special districts, I had to update this list, this official list of special districts. It's super outdated. People don't update that list at all. That list is like very incorrect. That list, there are people that are listed on that. Hell, I bet if you go back on that, my name is on some of these districts as like their chief counsel, even though I'm no longer their counsel. I bet if you look up certain districts, you'll find me, right? Because they just don't update it. People don't bother to update this list. It's just something that is maintained. Usually what you do is when a district is created, you put the name of the district on this list and the contact information, and you kind of leave it. If there's material updates, like for example, contact people, you're supposed to update it, but most people don't. So those lists are often outdated. Now, you're supposed to keep them updated, but people are lazy. They forget about it. It's one of these like regulatory things. Now, I tried to keep it updated when I was the attorney on that because I took that seriously. But that's one of those ticky-tacky things that people were paying me hundreds of dollars an hour to kind of stay up with. And I would do on a yearly basis. So that's one of those things that's kind of minor. And Disney suing based on them maintaining a list of special districts is a weak ass argument. Literally, it's an Excel sheet. Like that's what you're suing over is an Excel sheet that changed the name of the board members. Like that's really it. That's your grounds right there, buddy. Weak sauce. That's your injury. So this is a ministerial duty, right? It's a list keeping duty. So that is dropped. There's lack of jurisdiction there. So that was completely dismissed. So now we get to the CFTOD defendant. Now this is the best one. This is all the special district law. Now that we get into the merits, now we're going past standing, and we're getting into the merits. Yes, as Natasha said, when you find my name on the form, remember to search for Esquire. Leprechaun Gold today, $20 super sticker. Thank you so much, Leprechaun Gold, for the super stickers for the Shiba with a crown. Appreciate that. Appreciate your support of this channel. You, Tank Rat, all those that have come up big with support of this channel. Those memberships have really been big today. Lele giving those memberships, those guys joining today. Appreciate all your support. Make sure you smash the like button today. That's really a great one as well to help me out on this channel, or the Plussy if you're over there on Rumble. We've got about 130 people there on Rumble, and over here on YouTube we've got 1,235. An epic time for us. And by the way, I will have a summary video put out on this after we finish today. I'm going to create a short summary video so you guys can share it out, can get that out there to share out with people on the interwebs, because I know that people won't want to listen to always an hour, 2-hour stream. They might want a shorter version. So I'll have a version that's under 10 minutes to get out today. Lily Smith said, he said another lawyer who was claiming to be an expert in Florida law with opposing views, and he said you were wrong. Wait, really? Okay, well, I'll make sure to comment on that, but obviously he is wrong. But Lily, if you've got a clip of him saying that, send it to me. I don't believe he's actually said that. So if you actually can prove that, send me on Twitter, The Legal Mindset, write me on Twitter, or my email, andrewesquirelive@gmail.com. Email me the video, the clip, give me a timestamp. I don't think it's happened. But that being said, if he has, all the better, because I will just clap those Schmiegel cheeks easily. It's not under the best Florida lawyer. Yes, of course it is. Thank you so much, Adam Werford. Appreciate you base chat out there. Appreciate you very, very much. All right, let's go here. Florida law. As a general matter, the First Amendment prohibits government officials from subjecting individuals individuals, so mind you, individuals, to retaliatory actions after the fact for engaging in protected speech. So the issue here, guys, is this is not something that just affected Disney. It affected everybody within the special district. Just like a city or county, when something happens in your city or county, it doesn't just affect you, it affects everybody. It affects everybody equally. Now, you may pay more, you may give more, you may be really rich, you may be Ron Coleman rich, right? You may be just balling out. Or Jonas J. Campbell. I mean, that's just ungodly. I mean, that's Jonas J. Campbell. I mean, that's like a Rockefeller, right? If you are out there with that level of money, yeah, you may pay a lot. You may pay more than everybody else. That doesn't give you more rights. You don't get to claim ownership over your local government because you pay more, right? Donald Trump, because he pays more in Mar-a-Lago, doesn't get to claim more of ownership over that local government, right? It's not, that's not how things work, right? It's not how it works. No, paying more doesn't give you more rights, right? It also doesn't mean you're targeted because you pay more. That's not how that works in the law. It is settled law that when a statute is facially constitutional, it means on its face, in plain language, it's okay. A plaintiff cannot bring a free speech challenge by claiming that lawmakers who passed it acted with a constitutionally impermissible purpose. So this is Hubbard. You're going to see Hubbard again and again and again and again and again, because as I say, the 11th Circuit has held this many times. It's a clear case of settled law, and this settled law forecloses Disney's claim. So the case closed in one paragraph here. Paragraph 2. This is it. On its face, it's permissible. At any point under clear Florida law, plain Florida law, special districts can be created and destroyed like that by the state or the county or the city. Whoever creates them, whatever entity creates them, can destroy them. That's settled. There's no debate there. So even if you're trying to bring a free speech challenge, if the purpose is okay, you're not gonna pass. It's not gonna fly. Leprechaun Gold sends 10 Legal Mindset memberships. Thank you so much, Leprechaun Gold. Say thank you. Jim Satala, the wrench, gets one from Leprechaun Gold. Cyberpunk, Krieg, JNK, Hippie Kathy, Johnny Osprey, Martin Lawrence, Arrakis. Yes, looking out for Dune. I don't know if that's a Dune reference or not. John Sapola, Edward Connor, Mygins ID. You guys say thank you to Leprechaun Gold, who's hooked you up with a membership. Get that grift and get that gift. All right. So let's continue here. Hubbard relied on O'Brien, a leading First Amendment precedent. In O'Brien, a plaintiff burned his selective service registration card to protest the Vietnam War. Charged with violating a statute that prohibited knowingly destroying such certificates, he claimed the statute was unconstitutional because its purpose was to suppress free speech. But the U.S. Supreme Court rejected this claim. It noted the hazardous nature of inquiring into legislative motive, and it declined to void a statute essentially on the grounds that it is unwise essentially on the grounds that it is unwise legislation which Congress has undoubted power to enact, and which could be enacted in the exact form if the same or other legislator had made a wiser speech about it. So if there was, okay, let's say that a piece of legislation is passed by an idiot, okay? An absolute idiot passes a piece of really good legislation. A dummy, an absolute dunce. And everything he says about it is wrong. In fact, it's biased. It's hateful. It's all of these things. But there's another valid reason for passing that. It's legitimate. This is the standard with which we look at legislative decisions. Even if your representatives are idiots, even if they're dumb, even if they're biased, which, by the way, all of them are, on the left and on the right. They all have their biases. They all can be idiots. In fact, most of them are pretty dumb. Have you seen the legislature? Have you seen the people that were elected? Most legislation is passed by people that are just a hair away from the short bus. But that doesn't make it invalid, because as long as there is one single legitimate reason, you can be as big of a dum-dum as possible. It doesn't matter. It's irrelevant to the argument. So this is, to me, why this was DOA. This argument was always DOA because all they needed was one legitimate reason, and we have hundreds. We saw in the CFTOD audit hundreds of legitimate reasons for getting rid of the district. They didn't get rid of it. They just changed the governance structure, but there's a lot of good reasons for it. In other words, because Congress could have criminalized burning draft cards for legitimate reasons. For example, you could criminalize burning draft cards because burning shit is dangerous, right? That's legitimate enough reason to criminalize burning draft cards. Or because maybe that's the only copy they make. Maybe because it costs the government more money to make another draft card. All of those are legitimate enough reasons to do that. Now, whether or not that's wise legislation, whether or not that's good, we can argue about that. But is it legitimate? See, making the argument that it's stupid legislation is one thing, and that's something we can debate, whether it's smart or not smart. But you can't say it's not legitimate legislation. That's what they're trying to do here, and that just doesn't work. Lily Smith says, I'm banned from Twitter. I'll look for the video and send it the title on Super Chat. Thank you. Or Lily, just email it to me, andrewesquirelive@gmail.com. Email it to me. Email it to me. andrewesquirelive@gmail.com. I will check the video. Thank you, Lily. Just put in the subject line, Lily Smith, legal video. Thank you. All right. The 11th Circuit applied that clear rule in Hubbard. After Alabama enacted a payroll statute that restricted payroll deductions for public employee unions, they brought a First Amendment challenge. They contended the legislature enacted a law to retaliate against the unions. But on its face, the statute did not implicate any constitutionally protected conduct, meaning it was facially on its face constitutional. Plaintiffs' only basis for the claim was the alleged retaliatory motive that the lawmakers had, because they said mean things, because they used mean words. And precisely the challenge that O'Brien and the 11th Circuit decisions following it foreclosed, meaning you cannot say that. That's something that is clear. Courts shouldn't look up a law's legislative history to find an illegitimate motive for an otherwise constitutional statute. If we allowed people to pick through and find one thing that was wrong, that imagine how many laws would be overturned if all you had to do was find one mean thing that politician said. If you just had to find one mean tweet, everything gets overturned. Everything the liberals pass gets overturned. Are you kidding me? Everything that gets passed ever. There's always people saying mean things about the other side. If mean statements, mean tweets, mean comments, mean press statements are a basis to overturn law, there's no law getting passed. And it's not the job of judges to look through and pick out a single mean thing that was said in order to turn it over. That's subjective. That's, of course, the world that the delusional Disney pixie dusters want us to live in, a world that's governed by their fee-fees rather than by the facts. The facts is the Disney Corporation has been failing. They've been losing. They've been listening to bad advice. They've been drunk on DEI, which I've got another video that's going to come out soon. But I don't know if you guys have seen this, but there is a video from a woman who's doing a DEI presentation about how she forces people to adopt DEI. It's actually really scary when you see that this is what they're doing to companies, right? This is what they've decided to get drunk on instead of listening to the law, instead of listening to the facts. They get drunk on their political motives and their aspirations, let's say, their agenda, we'll call it. Okay. So a straightforward application of Hubbard resolves this. As Disney acknowledges, the legislature can determine the structure of Florida special districts. Boom! This is it. This, ladies and gentlemen, right here, this statement is what I have been saying for an entire year. This is me. This is all me. Only I was saying this. Nobody else was saying this. For an entire year, I was standing by myself, except for those that came around. I shout out to Ron, a couple other lawyers, but most people didn't even back me up on this. In fact, most other people mocked me. Even members of LawTube actually mocked me. They're like, Andrew's doing the Disney issue. He's deranged. People laughed about that because they thought I was crazy, right? But this is the one thing that I am very, 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 very confident on, and that is this single point here. The legislature can determine the structure of Florida special districts. They can be created and destroyed at a whim anytime as they please. Why do I know that? Because I've done it. I've seen it. They can be created and destroyed whenever they want, period. That forecloses a lot of this argument. Disney does not argue that the First Amendment would preclude the legislature from enacting challenge laws without a retaliatory motive. So they could have been just a month later passed a different law and, oh, it's totally okay. Disney made no argument that they can never disband Reedy Creek. They had a right to Reedy Creek. They never argued that. All they could argue is that specific motion, that specific legislation. But there could be plenty of other legislation. The laws here, as in Hubbard, do not facially impinge on any constitutional rights. As in Hubbard, the only basis for the claim here is that the legislature had a retaliatory motive. So as in Hubbard, there is no cognizable First Amendment claim. Boom! No First Amendment claim. Disney resists this in several ways, but it cannot escape Hubbard or its holding. First, they say that they inquire into legislative motive to determine whether a facially constitutional statute was enacted for an impermissible purpose. Disney cites race or religion cases, as well as cases involving statutes that are designed to regulate speech. But this case is not that. This isn't about regulating religion. This isn't about suppressing the exercise of religion. This is about a special district. This is not a statute that says you can't believe in God. This is not a statute that says you can't be a woke retard. This is something that's not something that says you can't go to Disney World. It's not something that says you can't say gay. And yes, the camera is shaking a bit because this table I'm on, this is a not my normal setup. It is a small, like little composite board table. So every time I emphatically smack my hand on the table, the whole thing wobbles. Thank you for the super sticker, Leprechaun Gold. Appreciate that very, very much. The Shiba there. Thank you so much for that support. So yeah, there we go. All right. Let me go down to the next one, which is number 2. Second, Disney contends that the challenge laws explicitly target it. That they explicitly target it. The Hubbard principle does not apply when the law is challenged as a bill of attainder. Although Disney does not challenge the laws as bills of attainder, it labels the laws as attainder-like and attempts to squeeze into that exception. Well, this is something that would specifically target Disney, that would name Disney and Disney alone. So when you single out somebody, it would apply. But here's the thing. It doesn't explicitly target Disney. It doesn't single out a specific group. Why? Because Disney is not the only landholder in the district. Oh, no. In fact, there are many landholders in the district. There are other people who own property in the district. So Disney is not the only one who's affected by this. You would have to see a case that was brought by Hyatt, by Marriott, by the Dolphin, by Shades of Green, by everybody, every other, the frickin' Perkins would have to sue. Would have to sue. That's the issue. That's the issue. And yes, let us laugh. Let us take a moment to laugh. It feels so good. It feels so good taking that dub. And let's continue. There's the third part here, the third argument here. It argues that even if it doesn't explicitly argue it, they come close to a Hubbard exception. There is no close enough exception. So that doesn't work. A law either explicitly singles out a group or it does not. And the law here does not. In arguing otherwise, they rely on Judge Posner's decision and the Fraternal Order of Police, Hobart Large, number 121. But in that case, in which a Florida First Amendment retaliation claim failed because the challenge law did not single out anyone, it only undermines their position. So literally, the only case which they cite undermines Disney's position. The law does not mention Disney. It doesn't talk about Disney at all. It doesn't direct anything at Disney specifically. Disney is not brought up at all in the law. This is what I said from the beginning. The only person that was hurt was the Reedy Creek, which is the CFTOD. They're the only people that could have challenged DeSantis, was the district itself. But they didn't do that. Now, they did have a chance to do that. I actually brought this up. I actually gave Disney their best argument. I gave Disney their best argument. I said to Disney that they needed to, when they were Reedy Creek, they needed to challenge as a board it when they were Reedy Creek. They didn't do that though, because they would actually have to argue Florida law. And they didn't know Florida law because they had nobody that actually knew it. And they wanted, for political reasons, to argue First Amendment. They chose to argue First Amendment because they thought it would get them the most sympathy, because their shill media could use that card, because their simple Cro-Magnon, unevolved brains can only understand the simplicities of my First Amendment. They can't actually argue the substance of the law because they had nobody competent advising them on that. They had the ability to challenge some things, and they could have brought it up. They could have made other arguments. They didn't do that, and they would have had to do that when they still controlled Reedy Creek. They didn't do that. They failed to do that. They should have done that. Oh, we're going to get into the copium. Don't worry. The copium is flowing. Do not worry. Do not worry. We'll get there. We'll get there. All right. Disney is left to argue that they go beyond the law's text. The argument is that it ignores the holding precluding retaliation claims against facially constitutional laws. Disney acknowledges that it is not the district's only landowner, and other landowners within the district are affected by the same laws. Womp, womp, womp. There we go. It applies to any special district established by special act prior to ratification of the Florida Constitution. Remember that this law disbanding Reedy Creek not just disbanded Reedy Creek, it actually disbanded 6 other special districts. So the law that disbanded Reedy Creek disbanded 6 other special districts. In fact, Reedy Creek got the benefit of being the only district that was able to be successfully reformed. So in fact, if anything, they got special benefit, not burden, because they were reformed. The other districts were all wound down and dissolved. So this is an issue here. While it's true that the laws did not affect all districts, it is at least true that Disney faced the brunt of the harm. But Disney offers no support for its argument that the court is to undertake line drawing to determine just how many others a law must cover to avoid singling out. So, for example, this law covered 6 special districts, but it didn't cover all 1,000 special districts in Florida or 2,000 special districts in Florida. It didn't cover all special districts in Florida. So, but Disney doesn't say how many special districts must be covered by a law for it to be legitimate. Is it 10? Is it 20? Is it 50? Is it 100? The court doesn't get into line drawing. And I know some of you said the text was small. This line drawing, how many do you have to cover by a law for it to be legitimate, right? You don't get into that exercise of, oh, well, it only affected 6, so that singled us out. Well, if there was 7, would that be okay? If there's 8, would that be okay? If there's 10, would that be okay? Court doesn't engage in that. That's speculative. That's not something the court engages in. Disney says that far from trying to ferret out some hidden or opaque retaliatory motive that rests on clear, consistent, and proud declarations of the state. But Disney cites no authority suggesting this is a meaningful distinction. Disney, so what the court has said here, and this is an absolute own, the court has said that Disney made a bombastic statement without providing any proof whatsoever to back it up. All they did was made these empty statements without providing any proof at all to back it up. Any proof to back it up. Mwah. Beautiful. Beautiful. So going on here, it says, at the end of the day, under the law of the circuit, courts shouldn't look at a law's legislative history to find an illegitimate motive for an otherwise constitutional statute. Because that is what Disney seeks here. It fails as a matter of law. Conclusion: the motion to dismiss is granted. The clerk will enter a judgment that says this case was resolved on motion to dismiss. Plaintiff's claims against the governor and department secretary are dismissed without prejudice for lack of subject matter jurisdiction. Plaintiff's claims against the Central Florida Tourism Oversight District board members are dismissed on the merits for failure to state a claim. So there is a difference here. So technically, they could try to make a claim, try to refile against Ron DeSantis and the secretary under different means to try to get some sort of jurisdiction, to try to get standing. They won't. It's not going to work. They could try. It's not going to work. They gave their best arguments and those were trash, right? But on paper, they could refile. It's not going to happen. But there's a decision on the merits. There's a dismissal on the merits. So you're foreclosed from bringing anything against the CFTOD as to this claim. The file is closed January 31st, 2024. Alan Windsor, U.S. District Court Judge. Boom! There it is, people. We are done. Case closed for the federal case. Now, we still have a state case. But mind you, this state case is going to be against Disney. Disney is a defendant. So Disney passed these illegal last-minute agreements, which are going to be invalidated. And the entire argument is real estate property law, which is another one of my specialties in Florida. I did land use law. I did property law. It's also 100% my wheelhouse. It's all special district law. It's all things dealing with entitlements, development. That's what I did. That's what I still, in fact, I do that part-time. I still do advising, consulting on that. And guys, if you're in Florida, you need some advice about development, special districts, holler at your boy. Your boy's here. So that's something they're going to lose on, and that's something I'll continue to cover. Also, I was going to cover stuff like the monorail regulation because they're starting to regulate the monorails now. I was going to cover the Courtney Clenny trial. I was going to cover Epic Universe. That's all going to happen in a future stream. But for now, we have to cover Disney stuff. We have to cover the Hopium. If you got HOA questions, I can handle HOA stuff. I can address some HOA stuff. You can do that. Of course, if it's work stuff, you know, there will be a bill, right? So just understand that. Scorpion says camera's shaking because Peltzilla is powering up. Oh, I'm going to get into Nelson Peltz, all that stuff. That's future episode. Don't you worry. We're not going anywhere with our Disney coverage. Disney coverage is not going to stop because of this. First of all, we've got a lot to do here. We've got a lot going on in the future with Disney. Disney is not done yet. In fact, guys, I'm calling it now. Just like a year ago, I called this case. Listen to me and listen to me now. Criminal charges, civil claims will be brought against former members of Reedy Creek. I'm calling this now. And I'm going to say I told you so on this as well. This is something they've been cooking for a minute on. That stuff is coming. Ron DeSantis is still governor. And when I said, look, this presidential stuff, that's done now. We're back home in Florida and we're focusing on these issues. And now that we're focusing on these issues, the only thing I'm questioning is the number of charges they'll bring, not whether or not they'll be brought at this point. And shout out to Ron dropping the castle. There will be more emojis. Do not worry. And guys, as you support, as I get more memberships, I will obviously drop more emojis, get more emojis created by my artist, who's a fantastic artist, by the way, and gets them done so well. So well. Let me make sure I got everybody here on all of the platforms. And shout out to everybody on locals. On locals, I said I'm bouncing around like I'm writing something. Yes, thank you, locals. Appreciate you. All right, let's get to the copium, shall we? Because there is indeed a whole lot of copium. So let's look at some of the posts on Twitter and how people are melting down about this, or how they're just kind of taking this. So obviously I post here, boom, baby, been saying for a past year that Disney versus DeSantis case was trash and would be dismissed. For over a year, Disney shills pixie dusters and YouTube lawyers who know nothing about Florida law, much less special districts, said I was wrong. Well, here it is. Case closed. Right? So, of course, you get here Badger 1848, who's got an interesting collection of flags there, says it's easy to predict an outcome when you know that one judge making the decision is a Republican and a DeSantis ally. It's much harder to predict what the 11th Circuit or SCOTUS will decide. So congratulations, you knew who the judge was. Look at this. Sorry, easiest way to predict an outcome. Could be the same law passed by the legislature and signed by governor if both were a D and not R. If yes, then falls under valid law for how states regulated their entities. To say gov can't pass tax law to affect companies that support others. Matt. Oh yeah, sorry. This is actually legit comment. Sorry, but this is the copium here, right? So the copium is sorry. So Steve is cool. Steve's cool. We got to like Steve here. But Badger here is the one who's being the test, and this is a lot of the copium. People trying to say that this is a Republican, right? That the problem is that this was easy because this is a Republican. A couple things. Once again, many Republicans, many so-called conservatives came out against this. Let me actually show you guys a point here. Now, this guy, he calls himself an independent now. Obviously, he used to be a Republican, but some of you may or may not know David French. If you remember David French, attorney, right? He posted this a year ago. This is from David A. French. DeSantis accused Disney of pledging frontal assault on duly enacted law. If the First Amendment protects anything, it protects our ability to object to laws passed to govern us. So he was outright supporting Disney against DeSantis here. This is a year ago. This is April 30th, 2023. This is a quote unquote conservative or somebody who was a Republican, now quote unquote independent, right? These people were coming out here. And supporting the First Amendment argument. And there were a lot of other quote unquote Republicans, right? The conservatives, right, that were supporting the huge, massive woke corporations. And in fact, there are a lot of conservatives that they just irrationally back up large corporations because a business, right? It doesn't matter how much DEI or whatever they push into it. Nope. We got to support it up because business, right? Because, conservative equals business, and anything that goes against any business is bad, right? That is, David French is possibly the epitome of a conservative cock. I agree, but that's why I show him, because it's a bad argument to say that all conservatives support this, all Trump supporters support this. No, in fact, I would say a lot of them didn't support this. But if you know the law, if you understand the law, you know what's going on. You know what's going on. Scorpion Black Dragon says, Iger's nightmare greater than DeSantis becomes Trump AG. Oh my God. If he's Trump AG, we're talking SEC, we're talking federal charges against Disney. That would be insane. And if that happens, oh boy, corporate America would quiver. In fact, that would be a good reason to make him the AG. Now, I don't know whether he would want to take that role or not, but honestly, if he became the AG and just wrecked if all he did was wreck woke corporations and their DEI propaganda and going after for their bad decisions and also going after them for their plain and simple criminal activities, I'm okay with that. Because there's a lot of white-collar criminal activities that are going on that are just unprosecuted. All you have to do is prosecute it. But I think Ted Cruz, someone said Ted Cruz would be a better choice. Maybe. I'm not trying to advocate that. I think he needs to stay as long as he can as governor of Florida. That's my personal opinion. But that said, personal opinions aside, it doesn't matter who's the governor. Any person with a brain would press charges against Disney for what they've done with Reedy Creek. Over here on locals, we've got a tip here, $5 tip. So let me read that. Uncovered Lamp says David Drag Queen Story Hour is part of the blessings of liberty. French is terrible and his wife is worse. He's not at all conservative. Timing wise, was this sooner or longer than you expected, or about when? This was about when I expected this to come out. Now, Disney is very good at delay. Disney is excellent at delay. In fact, they've managed to delay the state case a significant amount. They've managed to delay the state case a lot. So this is something that is huge in terms of delay of the state case. However, I think they're ultimately going to face the same fate in the state case. I think that the state judge is trying to make sure that everything is locked down for appeal. They're trying to give as much deference to Disney as they can, but frankly, they're going to lose that one. They're going to lose that one just the same. So now that they know that they are stuck with the CFTOD, they're going to have to come to Jesus. And I think the best thing they could do, if I was Disney right now, and this is some free advice I will give them, and I will give Disney some free advice right now. So pay attention, rat lawyers, all you rat lawyers out there, legal, call your butt buddies at Disney, okay? You got Leonard French, strap on your Minnie Mouse ears, put on that skirt, go call your friends doing Drag Queen Story Hour at Disney Anaheim. Call them up, tell them this, reach a settlement agreement in the state case. Settle it out. Get some development rights, end the case, say, okay, we want development rights to build an extra hotel. We want you to guarantee we can build a hotel, an expansion, whatever. Guarantee what you're going to build. Get some basic development rights. Do that. Settle. You might be able to get a little something out of it. You might be able to get it. If you don't do that, you're going to get zero. You might be able to settle and get a tiny little bit. A tiny bit. If you do it now. If you wait, you're going to get fucked. They're going to get absolutely screwed. Incoherent Turd said, Alex Jones for all cabinet positions. That would be great. The Frogs. Congratulations on calling the outcomes on the start. Listen, it's not hard when you know the law. When you know the law, it's been obvious. It's obvious. It's been obvious from Jump Street for me. So it's not, honestly, guys, this was not a difficult one for me to call because the law is obvious. It's not about the judge or anything else. My only concern was getting an insane judge that would not care about the law because we actually have to worry about that nowadays in a world in which Soros is appointing prosecutors and people are just outright saying they're not going to follow the law. But any judge that's following the law is clear. See, nowadays, the concern in America is not whether or not, the law is clear. Oftentimes, the law is clear. It's a matter of whether or not people are upholding the law or not, or whether or not they're trying to push their political position through the bench. Over here on Zerumble, Occupant 42, my good homeboy here, says, Alex Jones for White House press secretary. Can you imagine those press meetings if it was Alex Jones? That would be amazing. Alex Jones's press secretary would be amazing. So there we go. We've got that copium there on X. On X. Some people have asked, is this going to be appealed? Highly doubt they would win an appeal. They might try something that is ineffective. They might try something that's inefficient, but an appeal is unlikely to be successful. Nicholas Atkins says Disney's federal case was always woke propaganda that panders to their monetary lords and to be savory feed for the media shills. Does this set precedent beyond Florida for laws that have similar for states that have similar laws? Honestly, Nicholas, it doesn't, because this special district law is unique to Florida. Florida is one of the few states that has special districts like this. The closest state to it is, shout out to the governor over there, is Texas. In fact, a lot of the times when I was doing comparative law, and I was actually advocating for other states to adopt Florida laws, I was actually advocating for developers in Texas to petition Abbott to adopt similar laws to Florida. Texas has special districts. They don't have the same robust law as Florida. Now, mind you, the reason why Florida has special district law and the purpose of special districts is to develop Florida, because people don't know this. One of the things about Florida, which people forget, is Florida was the last state in the continental U.S., not Alaska, not little islands, right? The last state in the continental U.S. to be developed. Florida was relatively undeveloped 100 years ago. There weren't that many people in Florida. Florida was really not that big. Now we're the third biggest state in the union? So Florida went from zero to hero. How fast? We were all swamp. It was all swamp ass a year ago, or 100 years ago. The reason why there were special districts is to develop fast and to make sure that the people who are getting the benefit of those services are paying for them. So what it's saying is, look, if you want to build a city, the people in the city should pay for the city amenities, not the people in the rural areas. So if you're a farmer, are you benefiting from all the city amenities, the light poles, the streets? No, you want the city to pay for that. If you are in a specific neighborhood that's very nice and has nice parks, that has nice, amenities, it has a pool, right? Maybe it's got a community pool. Are you benefiting from that if you are living in the sticks? No. And that's what a special district is. It's a smaller unit of government. It's below a city. It's below a town. It's a very tiny area. Now, in the case of Reedy Creek, it's an exception because back in the day, they were willing to create this district for Disney and give it a massive size, bigger than the city of San Francisco at the time. They were willing to do that because it was all swamp ass. Now we're developed. Now Central Florida is booming. And yes, some of that is thanks to Disney. But just because it's thanks to Disney doesn't mean Disney gets to be the massa here. They don't get to control everybody and put everybody on the Disney plantation, right? This is not what's going on here with Disney. Disney doesn't get to be the boss in perpetuity, but Disney has. If anybody lives in Central Florida, particularly those that have worked in law, that have worked in permitting, that have worked in developing, for decades, Disney has thought they're in charge of Central Florida. And for decades, they did buy out the politicians. They settled cases. They gave massive political donations to Republicans and to Democrats. And they did that for 60 plus years. And it worked. They were able to buy people out for decades. But only after all this time did people look at it and say, should we really be doing this? And by the way, guys, there were multiple attempts throughout the years and multiple threats to invalidate Reedy Creek because what they were doing was illegal. There were multiple challenges. Many of them were settled. There were payoffs. There were all sorts of things that went on to keep Reedy Creek around when many people knew it was sus for years. So do I think this is limited to Florida? Probably. I think this precedent is limited to Florida because it's related to special districts. So I don't think it's much applicable, although Hubbard and the general thought behind Hubbard applies broadly in many types of cases. But in this case, it specifically applies because it's a special district and because this wasn't targeting Disney at all. The legislation doesn't even use the word Disney. Rupert Patterson says, aren't they just focusing on First Amendment because there's nothing else to even try? They could, Rupert, if they were good lawyers, they could have tried to argue, and this is what I'm trying to say, about development rights. This is a super nerdy topic. It's something that, frankly, I haven't even gotten into because it's so nerdy, it's so specific. They could argue about development rights and entitlements. Anybody who knows about land use and development, you know about entitlements. What an entitlement is when you are given the credit to build something. So let's say you contribute towards conservation land. And there's actually quite a lot of Disney conservation land. Let me pull this up for you real quick. Let me see if I can find an actual map here or an image, right? Because there's an actual wetlands that is Disney conservation land. Let me see if I can find this. This is I'll give you guys a picture of it. And I think this might be it as well. Maybe not. Okay, let me show you guys this. Yeah, okay, so here we go. So there is all this conservation land. So this is what Disney Wilderness looks like. This is what most of Florida looks like, right? Anybody who's lived in Florida, this will be very familiar to you, right? Floridians, where my Floridians at? F's in the chat. F's in the chat if you're a Floridian or you've been to Florida and you've seen stuff like this. This is what Florida is supposed to look like. This is what Florida did look like for years. Swamp, mangrove, scrub grass. Disney maintains a large area that looks just like this. Shout out to my swamp life, my swamplands. F's dropping in the chat over here. Also on Rumble. Good to see my gangsters over there on Rumble as well. So yeah, obviously that's what it's supposed to look like. That's what Florida is. And you are given credits, they're called conservation credits, for maintaining the land in this version, right? So maintaining the land in its native version, you're given a credit. This credit allows you to build stuff. So whenever you build stuff in Florida, you have to keep certain amount of land as conservation land. And yes, native Floridian counts, definitely counts. So you have to keep this conservation land. Well, Disney keeps a good amount of conservation land. They actually keep, and you can see here, here's the map. All of the green here in this map, it's kind of fuzzy, guys, but all of that green is conservation land at Disney. There's a lot of conservation land. They can make an argument that even though Reedy Creek maintains that land, Disney was the entity that gave that land over to Reedy Creek. That Disney is the one that gave that. And they can make an argument about that. Now, I'm not going to go any further with that because I don't want to give them the full argument. That's just a tip, just to see how they like it. That's the basic argument. So there is an argument they can make. They just didn't make that because none of their attorneys are Florida attorneys. They literally hired their same woke attorneys that are defending them against gender lawsuits in California and DC and New York. Look at the names of the attorneys. They hired the exact same attorneys, the exact same out-of-state attorneys as they did in other cases. One dickhead said, how are you at eminent domain in the state of Florida? I'm pretty good at both ends. I'm no longer in the state of Florida. I live in Asia, so I'm not representing anybody directly, but I've advised on a lot of eminent domain cases, and I've been on both ends. I've been on the government end when they're taking the land, and I've been on the other end when land is being taken. So I know a lot about eminent domain. I taught property law for Andrew Branca's American law courses and taught all about eminent domain. There's a lot of good and bad about eminent domain. I think eminent domain can be very abused. And in fact, Disney was abusing it. When I was representing Bonnet Creek, Reedy Creek was abusing eminent domain to take part of our property. It was complete BS. They were abusing the laws. It was really, really horrible what they were doing, and they were negotiating in bad faith. It was absolutely horrible. And that's one of the interactions I had with them when I dealt with the rat across the table. Frank's here says another one bites the pixie dust. Oh yeah. Ike Bravlosky says, I'm late and gay. Happy for your victory lap. Happy you made it here. And we have 1,338 people here in the chat who are happy to be here. And we're almost at 1,000 likes, guys. Only 130 more. Guys, if you smash like button here, let's get there. Tankrat says, lol, I'm so glad that Iger's Disney takes it in the shorts today. Iger's Disney is circling the toilet castle rat. Keep up the good work, keeping us unbreaded. You know I'm going to keep you unbreaded, Tank Rat. I know you're pumping that jet fuel out there in the Middle East. But listen, man, I'm going to keep you guys updated on this from wherever I am in the world, whenever I am, whether I'm traveling or not. I'm going to keep you guys updated on this, and I'm going to keep updated on all of the copium here because you know it's going to flow. And if you look at this today, you can already see. Let's just do a quick browse at the copium and see just in the titles, right? I'm not even going to go through these articles. We'll do it on another day where we go through in depth the copium. But look at this. Disney loses First Amendment fight with Ron DeSantis. Disney loses First Amendment lawsuit. Disney loses against Ron DeSantis. Judge dismisses the claim that DeSantis retaliated. Disney loses. Oh man. There we go. Just so much here about them just losing. And who is going to come through and say, I told you so? Just your boy, just me. Marcus Squintus says, recently Glenn Beck mentioned big Ronnie D for Trump's future attorney general, if and when he wins, as this is DeSantis' last term as governor. Imagine the horror on the Disney board of directors' face if that were to happen. Best case for Peltz. This is a great case for Peltz. This is a huge case for Peltz. You know how this empowers Nelson Peltz? He can call up and say, look, the best thing we can do right now is we can go and we can talk to, we can come. If Nelson Peltz comes in, he can talk and say, look, I don't agree with this Iger bullshit. Iger's crazy. I'm trying to stop him. Let's settle the deal. Let's settle the state case. The best thing Peltz could do is get in and settle the case. And guys, there is a reason why Nelson Peltz, in all of his statements, has not brought up the lawsuits. Have you noticed that? Have you noticed that Peltz hasn't brought them up? Because he may be the guy who has to settle them. Peltz is not an idiot. He knows what the risks and liabilities are. There's a reason why he doesn't bring them up, because he may have to be the one to settle them. So it's smart that Peltz isn't going down this road. It'll be interesting to see if there's any reaction from Peltz after this decision. I think that Iger will make a statement. In fact, I'm waiting for Iger to make a statement, because Iger is going to have to make a statement now. And I am just waiting for him to make a statement on this. He's going to say some dumb shit. That Iger is going to make a statement. It's going to happen. Whether it comes in an earnings call where somebody calls in on the earnings call and asks him about the lawsuit, he's going to make a statement. He's going to stick his foot in his mouth, and we're going to catch him on it when it happens. And it could be something that he makes a statement and that gets him in trouble with the SEC, because now he's messing with liabilities of the company. Now he's really messing with things that he needs to disclose to the SEC. He's really stepping in hot water now. Chuck in Tennessee said, the mouse gave it to me in the rear over the years. I'm sorry to hear that. You might want to try some icy hot for that one, maybe. Maybe. I don't know. you might want to try that. So that's what I expect. Now, in terms of timing, obviously the state case, it's going to be something that's going to go out and it's going to continue for a while. There's some more copium here. Let me get this copium here real quick, because I know people are going to have this big copium about this. So real quick, this is one here that is happening on YouTube, on X. Chico said, Universal has special treatment should that end. I love this follow-up. Lol, they don't. Universal's special district does not operate under the same BS rules Disney had. Universal's operates by the law instead of as an arm of Disney. Yeah, it's not even close to the same thing, right? So shout out to Memento Mori. What I've loved more than anything, guys, is that you guys have learned the law and that you guys have become educated on this. And what I have seen is that people like WW Pro, Jonas, Valiant, Ron Coleman, these guys all now know Florida special district law, because I taught it to them. I said it to them. I explained it. And I love that people are learning, because look, I love having fun on this channel. I love hanging out with you guys. I love just shooting the shit. That's why I have anime streams. That's why I talk about Warhammer. That's why I get on and I stream, because I have fun. But I love that you guys are getting educated and learning, especially that I'm able to share this expertise, something that I never thought I would share with the world. I'm so happy to share this with everybody, right? That's why this topic to me is something I'm not giving up on. But yeah, this is something that clearly you can see. Universal, they have a CDD, a community development district, that was adopted by the county, that is under a completely different set of laws under Chapter 190 of the Florida statutes. It's completely different than a special district created by a special act of law. That is 100% different. Do not let anybody tell you that Universal has the same thing. It's not even close. It's not even at all the same thing. It's like saying, for example, let me put it this way. It's like saying that Australian rules football and the NFL are the same thing. Okay? It's pretty much the same. It's like saying rugby and football are the same because they involve a ball. It's asinine. It's like, well, rugby uses a ball and football uses a ball, so it's the same thing, right? Right? Happy to share this, Elizabeth. Thank you for being a member for 3 months, and appreciate all those members out there who've come through for months and months and months. It's been awesome doing this with you guys. Hillis Mallory says, you think the FTX and Disney lost money at the time by the CFO will be part of the legal entanglements in the future? I think that Disney has a number of legal issues that they're going to have to address and deal with here. There's a lot that they're going to have to answer, but I think one of the things is their books. And we saw, and I hope Mexican Iron Man and I get to stream on this in the future more, but PricewaterhouseCoopers pay attention to Price Waterhouse Cooper. They are behind a lot of the shadiest shit in accounting history. They were behind some of the accounting scandals of the past. If you look at some of the biggest white collar accounting scandals, Price Waterhouse Cooper was there, and they're behind the accounting for Disney. If you recall, remember that video we showed? Go back my old video where they showed the video of the internship where they were given cookies by the trans fairy godmother and given free trips to Disney, and that's their internship. Yeah, they didn't do any actual auditing of Disney. They just literally hung out at the Grand Floridian and ate some cookies and went to Disney. This is a completely captured institution. You're supposed to be an independent auditor. They're anything but being independent. Anything but independent. Joseph Benowitz says, I laugh as the mouse falls. The castle's burning, baby. And yes, burning castles in the chat. I know Wisconsin has special districts and historical districts, but what I'm saying is that Florida uses them the most. So they're the most common in Florida by far. It's not even close. It's far and away. Speaking of far and away, shout out to Is This Live dropping 20 Legal Mindset memberships. Also, shout out to everybody dropping the castle emojis in the chat, burning it up in the house and burning up these Legal Mindset memberships. Thank you so much, Is This Live, for helping make this a green stream. And if you guys were gifted a membership by Is This Live, go ahead and say thank you. Say thank you, Jonathan Cass, Jan N, DL Fendel, D Prez, Heard Not Seen, George Gator 87, Cerebral Failure, Naz 37, Brad, Legendary Racing, one of the OGs, Jennifer Douglas, Mike L, John Rosengard, Serenade, Donald Young, Daniel Lindsay, Ben Togel, Dagan Ming, Mitch Janik, and I think that's it. Oh, Sheep as well. Say thank you to Is This Live, who's been an OG. Thank you, Is This Live, Tank Rat. You guys coming up big, saying you're welcome. Thank you so much. Appreciate you guys. Thank you for your support of this channel. Helps me do this on the regular basis. Helps me do this essentially as a job. This isn't the only thing I do. I do other stuff. I do other work, but this is a main thing I do. So your support of this channel helps me. And once again, guys, now that we have 1,000 of you guys in there, we are almost done with our Seedy Creek project. So Seedy Creek is here. We are almost done with this project right here. Right now we have, let me refresh this page, 191 backers, guys. Let's get to 200. Let's get to 200. We have 8 hours left in this project. So this project will end. We are going to add a page to this. I will definitely make sure it is in there regarding this decision. So make sure that if you like this information, back up Seedy Creek. This is both a parody of Steamboat Willie and as well as a documenting of the corporate and government corruption of Reedy Creek. And this decision is going to be no exception. So let's get this there. We're almost at 3K. We're almost at the level of support of 200 backers. We're 9 away here, almost a 3K USD for this project. So thank you so much, guys, for supporting it. It's going to be a fun project. It's going to be digital. And it's going to go out in February. So just so you know, it's a great project to back. And the artist, Western Penman, he's a great guy. He's, I don't want to say what he's doing specifically, but he's a young artist. He's up and coming, and he is absolutely talented. Working through this. So please go support that. It is pinned in the description. So you have that pinned to the top, which is the supporting the Seedy Creek project. Click on that link. Danielle, my mod, is dropping it in the chat again, so you can get that as well. Deha Ko, my base Kyopo, dropping the $9.99 super sticker. Thank you so much for that. You need to start a Buy Me a Sandwich pie account for Danielle. Yes, definitely. My mods deserve a lot of support. I want to give some shout out to Don Baca and to Danielle. Both of them are amazing mods. They both are here almost every single stream. And so I want to give a big shout out to those guys and those guys that have been supporting my channel from the beginning. Also, guys, we are 2 likes away from 1,000 likes. 2 likes away from 1,000 likes. Also, a shout out to everybody on Rumble, smashing the pussy over there. You guys are keeping it very, very based. Saying rugby beats the hell out of the National Princess League. And look, I'm going to have a lot to say about about this Taylor Swift stuff. Look, I think the Taylor Swift stuff is an op. If you're asking me, the Taylor Swift stuff is 100% an op for a political endorsement. Expect that big Biden endorsement to come very, very soon from Taylor and Kels. That's definitely going to happen. But yeah, obviously, rugby and football are quite different, and perhaps in a good way. And appreciate those that are getting Seedy Creek right now. I see you guys dropping that in the chat, that are sold on that are checking out Seedy Creek, signing up for it. Thank you guys for running over there to sign up for it. I appreciate y'all and appreciate y'all supporting me on this channel as I cover this day to day and as we get this thing done. We get this thing done. That dog in him says, is it an OP like a got MIP campaign? What? It's original. Everything is original. It's all parody, but it's also educational parody about everything that's gone wrong with Reedy Creek, because we're not done with this saga, guys. This is the federal case, but we're not done here, right? So I know many people may think, oh, well, now Andrew's going to stop with the Disney stuff. Nope. We're not done. We've got way more to cover. And it's not going to be the only thing I cover on this channel. And you guys might not like everything I post. In fact, I notice when I post some things, like I'll post stuff about covering the Trump trials or everything else. Maybe you guys don't like that. Maybe you guys don't like anime and you don't like my anime streams. That's okay. I'm going to continue to cover a diverse array of topics, some of which you may love, some of which you may not. But this has been my keystone, and this has been something that I'm not going to give up on, this Disney coverage. And you can expect that coverage from me weekly based on the amount that Disney has been messing up over the past years. It feels like you non-animes are heresy. No, the non-40K is heresy. And by the way, big shout out to Arch. That was an amazing stream we did on Warhammer 40K, and a great discussion on gatekeeping and why gatekeeping is good. If you just want to see that stream and check out that, it is worthwhile to check out that stream with Arch just to discover an argument for why gatekeeping is good. Over here on Rumble, we'll actually get this. I'll just go over here to the tips here. Uncovered Lamp for 2 says, I heard Bubba is looking forward to getting to know Mackie, Money, and Pluto in the big house, if you know what I mean. And then $5 says Disney has already said it plans to appeal. Oh, Disney plans to appeal, does it? Oh, Disney plans to appeal. Oh, thank you, Disney. Thank you, Disney, for throwing more views and attention my way and more ways for me to say, I told you so. Thank you, Disney. Thank you, Disney, for the ability for me to cover this for another year. Thank you for giving me that gift. Please appeal this. Please appeal this. You are going to get wrecked. You are going to get wrecked in the upper courts. You are going to get absolutely destroyed. It is just free content for me. You're just literally giving me layups all day. You're giving me layups all day, every day. Chuck in Tennessee says, just become a captain. Yes, we're going to be captain of the SS Public Domain, which is the name of the steamship in Seedy Creek, the SS Public Domain. So, yes, you guys are going to be looking forward to seeing that. And, guys, we're so close on Seedy Creek. I just checked back in. We are 4 backers away from 200. We are almost there, reaching that goal of 200 with Seedy Creek. We're at 196. So thank you so much, those guys that came in, those 5 backers that just went there. 4 more, and we are at our goal of 200. You can see we're at 196 right now. Thank you so much, guys, for that. Thank you for coming up big. Thank you for supporting this channel. It has been amazing. It's been a great journey with you guys, and this is something that I'm going to continue for the next year. And appeal is just more ammo for me. It's just more I told you so. And as much as these people will try to cope with this, it's just not gonna work in their favor. They just don't understand the law. All right, guys. Well, listen, I don't like dragging streams out too long. You guys know that. That's the difference between me and other people. Some people, Valiant Renegade, who take 6 hours to answer super chats. Not me. Not me. Your boy gets it done soon. So we have one more on Rumble, and then I think I'm all caught up here. So over on Rumble, Occupant 42 says Disney Wars Episode 1. Civil law is wrapping up. Disney Episode 2. Criminal law is warming up. Yes. The next cases will be criminal. Will be absolutely 100% criminal. That's where we're going next with this. So it's going to the criminal story. The criminal saga is going to open against Disney. That's going to be oh so fun for me. That's going to be absolutely grand. Okay, guys. That said, thank you so much. Smash the like button. We got over 1,000 likes. We got 1,058. Thank you so much. Stay based out there, and I will catch you all on the next one. Peace.